Good evening, everyone. Good evening, good evening, good evening. And here we are for another edition of Wise Counsel Wednesday. So, welcome on, everybody. I'm going to give people a few minutes, seconds, or minutes, if you will, to come and join us. We're going to have a fabulous discussion this evening. But of course, let me introduce myself for those who do not know me. And so, what I will do is, for the time being, I am Christian McCray Stewart. I'm the founding attorney of McCray Stewart and Associates, where we are your trusted advocates for justice and peace of mind. For those who do not know, we have started Wise Counsel Wednesdays. And what we are doing is we're going to have various topics every Wednesday at 6 p.m. And we're going to answer your questions. We're going to answer the questions that you have so that you're equipped, so that you have the knowledge to know how to navigate the day-to-days of whatever legal issue you may be dealing with. So as you're joining on, go ahead and invite some people, do your tags, add followers, add highlights, so that people know that we have started and we have a great topic for this evening. And guess what? It's a topic that you all chose. All right. So we are going to be discussing today the difference between a will and a trust. And as we're going to get ready to get started, like I say, take a few seconds if you haven't already and tag some people, invite them to come and join this Q&A. This is going to be a great topic. First, as I stated, it was a topic that everybody was kind of in agreement with from our last Wise Counsel Wednesday, and it's dealing with estate planning, making decisions before the time comes about what you want to do with your assets. Good evening. My mother is joining us. Good evening. Good evening. So happy to see you on. And this is just an amazing topic. This is an area where a lot of people don't allocate a lot of time or consideration for various reasons. But this is one that we see on the day-to-day basis, and we're encouraging people have the conversation when it comes to estate planning. So we're hoping tonight that we can equip you. We can answer some questions if there's any myths or confusion or things that may come that you have when it comes to wills and trusts. We are here to answer those questions this evening, okay? And you don't have to delay at any point in time. You can go ahead and start posting those questions into the chat. And I'm just going to make sure as well that we highlight so that no one misses it. All right. And so with that being said, this is our Q&A time. So begin to go ahead and post your questions into the chat. In the meantime, what I am going to do is just begin to give a little background, if you will, about the differences between wills and trust. All right. So we can remove that so that you all can see clearly. And we'll put this here. It's our live Q&A session. So some of the differences between a will and a trust. So a will is a document where you are going to set out your last wishes, right? What do you want to happen with the assets that you have accumulated over time? What do you want to happen? Oh, you want to know something? We left our IG people out. So let me make sure that we go live here so that they can see it. And I think we are good there. All right. So a will. So you're able to determine where you want to leave, who you want to leave your assets to. If you have minor children, who is going to be the guardian. But some of the specific things when people are trying to determine, okay, do I need a will or do I need a trust? Sometimes in most situations, you're going to have both. But the thing about a will is that you have to go through the probate process, right? And for those who do not know, sometimes probate can take a little bit longer. That process is a little bit longer than if you're dealing with a trust, right? So you have to go through probate. It's not private, it's public. So all your assets and information, things of that nature, those are going to be available to the public eye. All right. And also money. Money is an issue because you have to pay for counsel 9 times out of 10. Like for instance, Texas, you have to go through probate. They're going to tell you that you have to have counsel, right? So that's something that you want to be mindful of because this is something that you don't necessarily deal with when you're dealing with the trust aspect of it. Now let's talk about trust. With a trust, it passed right through to your beneficiaries. You're not going to have the issue of them having to go through probate for your assets to be distributed. It's going to go directly to them. And so you're dealing with weeks or months for them to be able to get their assets. With a will, you're dealing with months. Sometimes it can be years, unfortunately. No probate is required. As I said, with your trust, you're not having to deal with the courts. Whatever you have set in place, that information, all your assets is going to go directly to your beneficiaries as you have it listed there. And it is private. It is private. And it depends on, and not even it depends, but in most situations, I think most of us, we're probably private individuals. We don't want all of our information out there. And when you're talking about wealth building, when you're talking about generational wealth, there's probably information that you don't want to be available to the public in regards to like what assets you had, what that distribution looks like, all those different things. And so a trust is a way for you to keep information private. And the cost. So you may pay a little more upfront. You may pay a little bit more upfront, but when it's all said and done, you're going to retain more of your assets, more of the wealth, if you will, for your beneficiaries, rather than it going to, as you say, an attorney to be able to navigate that probate process. All right. And so you all go ahead and throw your questions into the chat, and we're going to get them answered. Can I make a will to stand up in court? Yes, you can make a will that stands up in court. And so basically, so what happens with the will, right? You set out who your beneficiaries are, right? Because sometimes you can disinherit people, but everything that you have, you can say, look, I want my house to go to this individual. I want my car to go to this individual, all these different things. I want it to be designated to this particular individual. And what you have with the will is that you're going to have two, what we recommend is that, and then you're going to have two witnesses who are going to sign. They're going to witness that, look, this individual was in their right mind. They're a sound mind. They're of the age to make this will. They knew what they were doing, right? And you can also do handwritten wills, what they refer to as holographic wills. We do not recommend that, but some people do it. But yes, if you draft a will, you can be, and that's why you always want to seek counsel, right? So you ensure that your will is done in a way that it will stand up in court. And one thing that you see with that question, some things that I've seen is that you have people who may want to attest a will and say, oh, well, this is not valid or anything like that. I've seen people who put clauses in their wills and say, look, if anybody tries to attest this, if you try to make this circumstance or this situation cumbersome, guess what? You're disinherited. But yes, there is definitely a way to draft your will that it does stand up in court and you don't have to worry about issues later down the road. Is there a particular age at which a person should set up a trust? Great question. There is no age limit. There's no age limit. And that's whether it's a will or a trust. So you don't have to be, you don't have to be 45 or 50. Also, too, another myth is people feel like, oh, well, I have to be wealthy. I have to have all this income, all this money. That is not the truth. All right. I'll give you a prime example. So when I was in the military, when we used to have our new airmen come in and we would brief them, one thing, and we had a lot of airmen coming in, they're 18, 19, 20, and their mindset was, I really don't have anything. Why would I do a will? I don't need these things. And so what we told them is, regardless if you think that you have all the assets now, the thing is, everybody, 9 times out of 10, we're growing. We're not remaining the same. You're going to accumulate property. You're going to accumulate assets. You're going to continue to grow and expand. And what happens is when these changes in life takes place, the first thing you think about is not, oh, I need to go and do a will, or I need to update a will, or I need to do a trust. And so when you do these things early on, you have something in place that is going to allow it to be distributed to whoever you prefer. And that's the thing. I say this often, especially when I'm talking to people about wills and trust. And, people say, oh, when you pass, you can't take things with you. That's true. People also have the misconception, oh, you can't control. Once you leave, people do whatever they want to do with what you have built. No, you can be in control of what happens when it goes to your children. If you want to disinherit someone, if you want to give it all to a charity, some people do trust, and they do it specifically for their pet to be taken care of through the duration of their life. But there is no age limit. There is no age limit. You're 18 and older, go ahead and get something in place. Go ahead and get something in place, because most people don't do it. Unfortunately, we see a lot of people call us, and when they call us, what happens is they've had a loved one who's passed, and now we're in the court, and the state is deciding how their assets, how everything that they built and they worked for is going to be distributed among their beneficiaries or their heirs. How often should the will or the trust be updated? Wonderful question. Anytime that you have a life-changing circumstance, a life change, right? So say, for instance, if you were to create your will and you're single, that will is going to work. At the time that you get married, you definitely want to consider updating that will. You want to, and then 9 times out of 10, what happens with married couples is they do a mirror will. And what does that mean? So basically, when you look in the mirror, what do you see? A reflection of yourself. That's what their will is. I leave everything to my husband. I leave everything to my wife. Then say that you all have children. That's another time for you to update that will. Another time for you to update that trust. And so anytime that there's been significant changes in your life, you want to make sure that you're going back and that you're updating those documents. So that is a wonderful, wonderful question. And there's no limits. And sometimes it may not necessarily be a life-changing circumstance. It may be that hey, I left X, Y, and Z to my best friend. And life happens, right? That's not your best friend anymore. You don't want to leave those items or those assets to that individual. Well, you can go and you can change that will. Once you have them, they're not set in stone to the fact that you can't change them. One thing I will note when it comes down to trust is that you have different kinds. You have a revocable trust. Now, revocable trust, that's one that you can change, put assets in, pull assets out. When it comes down to an irrevocable, people typically use these for significant tax advantages. But once you put items in there, they're in there. So of course, but that is discussions to have with your attorney so that you're making sure that whatever you're pursuing is going to be what's right for you in your current situation. What happens if a beneficiary predeceases me? So typically you'll have a clause in your will that says, hey, I'm leaving all of my assets to such and such. Now, if that individual predeceases me, what happens is you can have it various ways, right? You can say, if this individual predeceases me, then I want it to go to this individual. Or you can have it. So say, for instance, let me do a mother is leaving or parents are leaving items to their children, right? So they have a son. Say, okay, I want my homestead to go to my son. If my son predeceases me, well, then I want it to go to his heirs. And so say if that son had a son and a daughter, well, then it would go to his children rather than just kind of being out there. Or it could be a situation where they only had that child, right? And so it's like, if I pass and my son has predeceased me, well, we want it to go to our great niece, Sylvia. And so there are some clauses that you can put in there for these situations. But of course, if you're not specific about it, what happens is that it will typically end up going to that individual's heir. And that's typically how you see it written. But you can have it where it's like, if this individual predeceases me, then I want it to go to that person, and so on and so on. Wonderful question. Wonderful question. What if I want to leave my house to my daughter? So this is what you would do in that situation. If you have a home, multiple homes, any type of real estate, in that will, per se, let's say that you're putting it in your will. In your will, you would just say, okay, the residence that's located at 123 Main Street, I want all of it to go to my daughter, such and such. And that will simply deal with that. Now, let's also speak about it in the aspect of a trust. If you wanted to go, so in your trust, what happens is you have a trustee, right? And the trustee is going to be responsible for making sure that everything is distributed to who it needs to be distributed to, when it needs to be distributed to them. And so what happens is you will be able to create a deed for your house that is going to list trust as the owner of the property. And what happens is you're going to annotate that home is going to be owned 100%. 100% of the interest in that home is going to go to your daughter at a certain time. And the reason why I'm making a note to talk about time is because typically we've had this situation. In a will, you typically don't see a situation where you're saying, okay, I want all these assets to go to this particular individual at this age. With the trust, you can set up when assets are distributed. Lord forbid, but you pass early and your children are young, right? They haven't finished high school. You have this trust in place. 9 times out of 10, when you're in your teens, your mid-20s, you're not financially savvy, right? And so you don't want a situation where your children may misuse what you have left to them, right? You want them to grow, you want them to mature. You can set up means to where at certain ages or certain milestones, or when they do certain things, that they're able to obtain certain portions of those assets, of their inheritance. Okay, if you're going to college, well, guess what? You're going to get this amount of money to pay for college. Or you're going to college, or 18th birthday, you'll be able to get a vehicle. If you decide not to go to college, but you're going to start a business, you can get this much money. So you can be very specific in your trust about how you want to designate things. That's why I say, don't believe the myth that, oh, once you're gone, that you don't have any control, you don't have any say. Yes, you do. Yes, you do. And that's why we want to come and we want to share this knowledge and answer these questions, because a lot of people do not know. A lot of people do not know. And you have situations where there's a lot of strife, there's a lot of pain, there's a lot of hurt. And then people are fighting. They are fighting over what you have accumulated. And that's just not the way to do it. Like we're desiring to build wealth for our children's children, right? We're desiring to leave something for our children's children. And with doing this, it's stewardship. Think of it as that way. Stewardship. All that you have obtained, all that you have produced, being a good steward of those things, what does it look like when your time is gone, and how do you want to pass those things down? You can also put businesses in a trust. I know a family who has created an amazing business. They never want that business sold. They want that business to stay in the family. And so one thing that I told them is that you do not want to make a provision in your will to say, oh, okay, it's going to go and be divided up between my children. And I never want them to sell it, because once everything is said and done, when the courts finish and the assets have been distributed, the courts have no more control. The courts are able, a judge is not able to come in and say, oh, I see that you're trying to list this business for sale. That's not what the individual wanted. That's not what the decedent wanted. No, that's what's going to happen. A trust is a document that you put in place, and you put a trustee there who's able to oversee and direct on those things. Yes, and definitely share, because even if people are not available now to come on, they can come back and they can watch this, right? They can watch it. So definitely continue to put your questions in there that you have. And the thing is too, so let me discuss this, because even though we're talking about the difference between two of these documents, some people wonder like, oh, well, maybe I only need one, or only, one or the other. I don't need both. Some people have both. And what do? They deposit a lot of their assets into the trust, and what they have with their will is kind of referred to as a pour over will, right? And so what does that mean? If there's anything that you missed out on, say, there's a potential bank account out there for whatever reason, you didn't list the trust, you didn't put it in your trust, or shortly before, your passing, you acquired other property, but you just didn't have the time to update the trust and make that deposit that asset in there. A pour over will is going to cover you, so that way those assets are going to be distributed to the appropriate individuals, right? Okay, is it more complicated if I don't do a will or trust and have a blended family? Oh, wow. Yes. So if you do not do a will or a trust and you have a blended family, it brings a lot of complications. And you can, yes. So prime example, we've had one of these situations, a case where there was no will, right? And so you have a husband who's married to his his wife, but he's had children prior to, whether it was a previous marriage or not. And they're trying to determine what's going on. So you're going to have a wife who's going to have an interest in the home just as a surviving spouse, right? But the children are also going to have some type of interest in there, especially with no will. And the thing is, what happens is that, so no, are they going to be at a place where they're just going to be able to kick that spouse out? No, but they're going to have interest in those things. And if you want, and then two, what happens is you have a man and a woman who come together and they both have children previously, right? So you have items that you had prior to marriage. Then you're going to have the items that you accumulated together. In this situation, like I said, you have mirror wills and you can have all those things listed out. But what I will tell you is that a trust is recommended because, as I say, you have a trustee who you're going to appoint. And when it comes down to your will, and hopefully you don't have a situation like this, right? Where you state that you have some things that you're going to leave to your spouse and everything is transferred over to them. And then they're going to include update their will and include all of your children. Sometimes it happens the way that you want to. And sometimes, unfortunately, it doesn't. I recently had a conversation with a family right now, and there's a lot of rift and wondering, okay, is wife doing right by dad's children? If there was a trust in place, you have that trustee, it lines everything out on how it's supposed to go, when it's supposed to go, and all those different things. And you ensure with that trust too, that your spouse is going to be taken care of. It's not a situation where, oh, and let me say that too, because some people think, oh, I can do a will and I can just disinherit my spouse. It doesn't work that way. You're going to end up putting your family through probate if you decide to do that. So that truly is a wonderful question. Yes, it is more complicated. Blended families, it's recommended for everybody, right? Recommended for everybody. Let me say that again. It's recommended for everybody. Do not delay in speaking with counsel to go ahead and start your estate planning, regardless of what stage of life you are in. But highly, highly recommended for our blended families. You just want to ensure that you have those things in place. If I have property in other states, would one trust suffice? Or do I have to create a trust for every state? No. So you can have one trust. You can have one trust. Because see what happens. And so with that question, this is one thing that I want to discuss. Typically when I do trainings or I'm talking to people about it, I'm saying, now don't just go out here and create a trust and then you don't deposit anything in there. And people are like, what do you mean deposit? It means you have to put the assets in the trust. Just having the trust means nothing, right? And so what happens is you will do a deed. You'll transfer. You do a general deed, warranty deed. So, of course, if you purchased the home, you know what happened. Whoever owned that home prior to, they did a deed that transferred the ownership in that property to you. Well, guess what you're going to do? Once you have your trust in place, you're going to do a deed to transfer that property to the trust. The trust is now going to become the owner of the property. And with that, so just like you can go and personally stay in Texas and go buy property in Mississippi, guess what? Your trust can own property in Texas, Mississippi, Georgia. Your trust can own property in multiple states. Multiple states. Now, what happens is when you're in the process of actually initially setting up the trust, one thing that we recommend is that whatever state you are in, find counsel in that state to set up that trust. That way you're just making sure that it complies with all the laws. Now, that doesn't mean that, okay, so say if I relocate, then do I have to do everything all over again? No, you don't. Most of the states are going to acknowledge those documents when you have them in place. For instance, I always give the example of the military. You have people who are stationed in, let's say, Louisiana, but their homestead, their domicile is in California. So if something happens to them, you're not going to have, Louisiana saying, oh, well, no, we're not going to recognize this will because they're domiciled in California. So you don't have to worry about those issues. But just in case there's some unique things that are taking place, you always just want to make sure you have counsel where you are staying to be able to provide you with the insight in regards to those particular laws. So yes, and so with trust sometimes being more costly on the front end, yes, totally a wonderful question. Like, look, I don't have to do a trust in every state just because I have property there. You don't have to worry about doing that. You'll be able to do those deeds and just transfer it over to your trust. Wonderful question. And more questions as you think about them. Just go ahead and shoot them in the chat. And oh, and I've had this question too. Some wonder, are my children guaranteed beneficiaries? So in a situation, so let's do this. Let's do a hypothetical. So you are a widowed individual, right? And it's just your children who are left. So when you pass, yes. So how the laws break it down is it goes to spouse, children. Then from children, it goes to your parents, your mother and your father. If your mother and your father have predeceased you, then it's going to go to your siblings. You have sisters or brothers. If they have predeceased you, then it will go to their children. And of course, that's kind of like the breakdown that you have. And of course, if there's nobody there, then what happens? You're having your assets go to the state. And so what you typically see for individuals who don't have children, they find charities, or of course at sometimes they may have like great nieces or nephews or people who they have built and formulated a relationship with, and they would leave those assets to those individuals. But yes, so if you are, as long as you're not married, your beneficiaries are automatically going to be your children. Is automatically going to go to your children before anything. And say, for instance, we're currently dealing with a case now. You have 4 children, and one of the children predeceased the mother, and so now the beneficiaries for, or the heirs in that placeholder, or in that slot, if you will, is going to be that daughter's children, since she predeceased the mother. And see, this is the things too that you prevent if you get these things in place, is that because what happens too, and sometimes why it can be costly, is when you don't do a will and it goes through probate, you have what they call a guardian ad litem. And the court will appoint this individual to then go out and identify all the potential heirs. And so they're calling potential witnesses or who may have known your loved one, and getting information. And then they're like, hey, how long have you known this person? How many kids did you know them to have? Is it possibility that they had kids outside of this marriage or this relationship or anything like that? It can get expensive. It can always cost, even if the only thing you have is a will, which is totally fine. Sometimes that's probably the best thing for an individual, depending on where you are. But it's more costly when you do not have these things in place. And so beyond the point where your family should probably just be able to cherish the memories that they have with you, they're in the process of trying to navigate the court system to see what's going to happen with what you have been building. And personally, having to see a loved one go through that, I would say it's not fair. And not that anybody does it to be malicious or anything of that nature. It's just not having the conversations, not really thinking about it, and not having a plan in place. But it becomes hard on families when they have to navigate that whole system, when they could be just, enjoying the time that they spent with you, going through the process of bereavement and not having to deal with the legal aspect of it. Can I leave my estate to my pets if I don't have kids? LOL. How does that work? Yes, you truly can. You can. And it happens. You have individuals who do that. They will, they create what they refer to as pet trust. And so what happens, they'll put all of their assets in this trust, and it's for the benefit of their pet. So what happens, they may have directions for items to be sold or whatever the case it may be, but you can definitely do that. It is not uncommon by any means. By any means, it is not uncommon. You can definitely create a pet trust, and you can be able to leave all of your items to your beloved fur babies. Nothing is wrong with that. And so with that, I mean, as she mentioned, that question, pet trust. charitable trust. I've seen people they do gun trust, right? Um, you can get very creative with it, right? But one thing I always say, make sure you are depositing in the trust. I dealt with a case. They had a gun trust, and guess what? Never put one gun in there. And so then when it was all said and done, it's like, oh, who do these items go to? Who they go to? Well, you go back and you look at the will and see pretty much if they say like, oh, my residual estate is going to go to my children 50-50. And so now they're trying to divvy up, okay, which item is going to go to who, when if you had it in that gun trust, you were like, oh, well, I want this, this pistol to go to this person. I want this shotgun to go to that person. It would already be set out. So it's just something that I want people to keep in mind. It's like, you're like, oh, why would you say that again and again and again? Because I've seen it again and again and again where it hasn't been done. And so it's just like repetition. Keep on saying it until you get it. You have it noted. So yes, wonderful question. Yes. So whenever you're ready, make sure that you can get that pet trust set up. Amazing, amazing, amazing. Are there trusts to help me qualify for Medicare? Yes. So as I was breaking down the types of trust, you have a special needs trust. And it's for that situation. So you say you have individuals who are on disability, they're receiving some type of benefits. Special needs trust is the way that you want to go, because what they have a cap, right? There's so much money that you can actually have in regards to some of these benefits until they have a cutoff line that you would disqualify. And so what happens is you can have this trust, and based on how the trust is set up, is going to distribute so much of an asset to you to ensure that you do not go over the guideline, the income guideline that is set. And so what happens too is you may have an individual, because the question was like, are there trusts to help me even qualify? So yes, so sometimes maybe you inherited something, right? And now you're trying to qualify, and they're like, well, you have this home and it's valued at this, various things. You can create that trust. And 9 times out of 10, those situations, the attorney is communicating with personnel or a point of contact with Medicare to discuss kind of what's going on, because there are some red tape, some I's you want to dot, some T's you want to cross, so that this doesn't hinder individuals and then they get denied. But you can create that trust so that way it puts you, as far as your income and your assets are concerned, within the levels or within the guidelines that they have created. And so I will a recent case that we were trying to navigate and figure out things is that you had siblings. The individual did have a will. And so what happened? He didn't have any children. He wasn't married. His mom and father had already predeceased him. It was going to go to his siblings. Well, his siblings were of age that had they acquired that home, it was going to be an asset attributed to them that had the potential to push them over those guidelines and could potentially negatively impact their benefits. So it happens. And so this is something to be mindful of. If you potentially have a child who has disabilities and you have these assets, and of course your plan is to leave all of these things to your children, go ahead and have a conversation now. Be consulting with an attorney now on, okay, look, how do I need to set this trust up so that it doesn't impact my child? My child will still be able to continue to obtain the benefits that he or she is receiving, to ensure that they're going to be able to live life comfortably and continue to be taken care of. So that is a wonderful question. And I'm saying there are so many different options and alternatives and things that you can do with your assets. I mean, it's surprising, but it all starts with having the conversation, right? And so I will tell you, in some conversations that I've had with people, the reason, because when you talk about doing a will, when you talk about doing a trust, people come from it from the standpoint of, oh, this is like when I'm not going to be here, right? But the fact that you're being in preparation does not mean that you're planning to not be here soon, right? All of us, all that time is going to come for all of us. But the thing is, we want to be prepared. We want to be prepared. And if you're like me, I know personally, look, I do. I want to have some control over what happens. I want to make sure that things are in place for my children. Should there be a situation where I my time comes prior to them being of age. I'm so glad that I said that, because it made me think of this thing as well. When it comes down to your will, so you can have a trust, right? Your trust is where all your assets is, where your home is, where your money is, where your 401k is going. All those benefits are going into that trust. Your will can set out who you want to be guardians for your children who are underage. That's also something that you can have in your will. And you can have some of those specific things in your trust as well, but it's recommended to make sure that you do have those in your will also. If you have minor children, that will is going to speak to, okay, should they be under the age of 18, guardianship is going to be created, and this is going to be the person who is going to be able to make all decisions related to those children. So you all are having some amazing questions tonight. And of course, definitely, as always, the ideal is for you to leave here equipped with the knowledge that you need or that someone else that you know needs. Okay. I'm telling you, if you have younger siblings, younger relatives, hey, have those conversations with them early, right? But let me make this and highlight it if I can. If you have older relatives, if you have parents, right? If your parents are still here with you, I'm recommending that you go out there and you have those conversations with them. Mom, dad, do you have a will in place? Do you have you created a will? It's important. It is important. And it limits a lot of the chaos that happens. I don't know if a lot of you on the live have experienced it, where someone passes and the strife that it can cause in families, the disruption it can cause among siblings. It's not something that you really want to see. But truly have these conversations and encourage your parents if they haven't already. And let me say this, there's another question I'm gonna get to here in 1 second. Another thing is, because even when you get to the place of doing these estate planning documents, I know we're specifically talking about wills and trusts, but you're able to put things into place. So say that you're incapacitated and you're not able to make certain decisions for yourself. You can select individuals who are going to make those medical decisions, who can handle transfers and transactions when it comes down to your assets. You're not in a position where anyone is making those decisions. Or in a case that I was actually in court today for, where there's a dispute of who should be your guardian, and maybe there's a company who does that, who is now overseeing your loved one. There's a lot of things that we have control over right now. A lot of things you have control over right now, but you have to act to get those things in place. Can I put stipulations on when and how my children receive assets upon death? Yes, you surely can. And I probably breezed over this one a little bit quickly. So thank you for asking that specific question, and let us break it down. So say that at the time of your someone passes and they have a child who is 16 years old, right? And no one wants their 16-year-old coming into thousands, hundreds of thousands of dollars, right? I look back and tell, when I was 16, I mentally, I would not have been there, right? To manage that money appropriately. So what happens is, you can have things in place to say, okay, look, this child can receive this much when they turn 18. The child can receive this much when they go to college. Like if they're going to go to college, then the trust is going to pay for their entire college education. If they don't go to college, well, guess what? You can't have access to your inheritance until you're 25 or till you're 30. That can totally happen. I've seen some, and you may say, you're like, oh, this is something that you see in a movie or you see in a book. Like, people have certain requirements, like, oh, you have to do X, Y, and Z before you get any of your inheritance. And see, these are trusts are powerful things. If you know that they exist, if you know how to utilize it, if you're with the right counsel and you truly just, you're telling them everything that you want, a trust can be drafted in a way that is truly, truly powerful. But yes, you can stipulate how and when children receive their assets. And that's key. It's key, and it is important, because like I say, if not, and you just have a situation where they just come into everything all at once, there's a high probability that they could misuse and misappropriate, well, not misappropriate, but misuse the funds. And then before you know it, within years, they don't have anything to show for it. You can have it where they're only going to get so much, but then those other funds have to be utilized for investments and things of that nature. You have a lot of control. So when I say, like, they're an amazing tool for you to utilize. They truly are. And as you are in the mindset, and as you are continuing to build that wealth, keep that in mind of what you can do with those trusts. And making decisions on how you want to utilize them. So that is a terrific question. Because, and this is the thing too, in that situation, the trust is the tool. The trust is the tool to put the stipulations in. The will is not the tool to put the stipulations in. It's not. Do you list out like the guardian and things of that nature, and you can be like, oh, this is what the guardian should do? But when probate closes, there's no overseer. There's no overseer. Are there certain assets that don't have to go into a will or a trust? Another great question. Yes. So with this, for instance, life insurance policies, they do not have to go into a will or a trust. Why? Because guess what? You're going to list your beneficiary on that soon as you set it up. So it's not even something that has to deal with probate or a trust. Now, can you put it into a trust? You totally can, but it doesn't have to go that way. When it comes down to bank accounts, you can have a transfer on death notice. So that means once you pass, that ownership of that account can go directly to whoever you want it to go to, right? Or say that you have your spouse. I get this question a lot. If my spouse passes, what happens with that account? Well, guess what? If you're the joint owner, it's automatically going to be you. That account becomes your ownership. 401ks, you list the beneficiaries on those accounts when you set them up. They pass through without a will or without a trust. It's going to go directly to your beneficiaries. Another thing that some people consider, and some people do, you can do a lady deed or transfer on death deed for your property. And what happens is, once you pass, that individual would file the death certificate with the county clerk, and then that property will automatically go to whoever the beneficiary or the new grantee is listed on that deed. So yes, there are definitely certain assets that do not have to go into a will or a trust. Now, some people, just depending on the amount, right? Or like I say, for instance, if they're dealing with minor children, they may elect to list the trust as the beneficiaries on those types of accounts, 401ks, life insurance policy, things of that nature. They may list that, but it's not mandatory. It's not required. Oh, yes, it is going to be up. The lives, you can go back and review them. So it will be available to you. It will definitely be available to you. All right. You all have some more questions out there? Great questions are coming. And then too, let me say this. Sometimes you're here, you're like, oh my, this is like great information. And a question is going to come like after we wrap up. Fine. That's okay. Guess what? You all can message us, and it doesn't even have to be about this particular topic. The point of us doing these Wise Counsel Wednesdays is for us to meet your needs. It's to meet your needs. It's not for us. We truly are here for you all. So what does that mean? When you see different posts and we're like, hey, what topics? What do you have questions about? Share with us. Like, even as we were wrapping up last Wednesday, that's how we end up coming up with the topic today to discuss the difference between wills and trust, because that's what the audience wanted. This was the question that they were posing and trying to determine, okay, what is the difference between this? So share those questions with us. Share your inquiries with us, because then that way we're able to come and serve the need that you have. Should I put my car into a trust or a will? So I would say, when it comes down to your car, unless it's a collector's, even if it was a collector's item, this is one of those that I can say you can put in a will. So let me do it this way. So say you have a person who's just starting out, right? And they're like, well, the only thing that I have is a car. I have a car and I have a couple thousands in my savings account. That's about all that I have. So in that situation, I'm not necessarily going to recommend a trust to that individual, because remember what we talked about too, setting up a trust, it may have some upfront costs, but you're going to save on the back end, right? So for being cost effective for them, at this point in time, the only thing that you need is your will, right? You can just do your will and you can leave your car in there to whoever you want to. Now, if I'm dealing with an individual who has accumulated a lot of assets, and maybe say that they have some designer cars or collective cars that they are collecting, right? Some of those old-fashioned cars, like, oh my, I see some of them that they keep up and they just look amazing. But you have those situations, they're like collector items. Those might be some that you want to put in a trust, because guess what? You can put some restrictions on there. Oh, you can't sell this car, or if you do have to sell it, this have to be the circumstances surrounding it. So it can be either one. But if you're, for our younger people, minimum assets, I'm not going to recommend that you're creating a trust simply to put your car in there. But if you're accumulating so many assets and you maybe have those collector items and things of that nature, a trust potentially may be something to consider. And also, let me say this, even with all the options that are out there, it's ultimately is what you, as the individual, what does it look like for you? What do you want to happen? And so based off what you want to happen, we're able to advise you to say, okay, this is what you need to do. You need to set up a trust to put X, Y, and Z in, and then you need to do a will. Oh, well, based off what you told me, you don't really need a trust. You just need a will. You don't have minor children, all these different things. And so it's not just like, oh, okay, it's blanket packages or blanket recommendations for each individual. No, what does life look like for you? Where are you currently at? Where are you trying to go? And what do you desire to happen when that time comes? Those are all important questions that need to be answered so that your estate plan is drafted to fit your needs and your desires. Also, let me make this note. When it comes down to wills and trust, so for your will, you're going to appoint an executor. This is the person who is going to be in charge, if you will, of distributing all the assets. When you just have a will and you go into the courts, it's not a lot of oversight, but for the most part, people don't really try to stray and do crazy things. Does it happen here and there? It does. But I say that to say, have somebody that you trust, somebody who also wants to do it right. Some people don't want to be put in that position. But now when it comes down to your trust, make sure the individuals that you pick are solid, right? Because remember, these are the ones that they're not going through probate. They're not going through the courts. They don't have those oversights, right? And you can have individuals do it. You can have private companies do it. Of course, that costs, right? And some people, if they have like these huge trusts with many assets in there, sometimes they do have companies do it. But as I've said previously, it's about what's going to be most suitable to your needs. Should I put my side business interests in my trust? Is this considered business succession planning? Yes. And so this was one thing that I mentioned about I had a family who created a business and they want that business to stay in the family. They never want it sold. And so they're putting that, I recommend it to them, put the business in the trust. They want to do a will, and I'm saying that it's not advisable because your business is going to end up being in a will. You know, but you advise, and then you allow people to make the decisions that they want to make. But yes, you can put your business into a trust, and you set out what you want to happen with that business. And just as the question mentioned, is that business succession? Yes, you have people who will set up, and some people do it, they have trust simply for the business. And they're able to lay out the terms, they're able to put things in place of how that business is to run and operate once the original owners, if you will, have passed. And that's the way, for instance, like I say, if it's something that you're trying to build a family business and you want to pass it down from generation to generation to generation, put that business into a trust to ensure that your desires are going to be met. So you can definitely do that. And then you can have it where, like, the income that comes from the business, so much is done to pay salaries. So much is going to be invested in other things. When I say what you can do with trust is, it's an amazing tool for wealth building and to continue generating it. But many people don't know about it. And many people don't utilize it to their advantage. They don't utilize it to their advantage. So wherever you are in your stage of wealth building, look, just have the consult. At the end of the day, just have the consult. That's the thing. Knowledge is power. When you know what's available to you and you know what your vision is and what you're going towards, then you know what things look like. So yes, maybe right now today, you do not need a trust. Do you need a will? Yes, you do. Everybody who is on this live, everybody who's going to come back and watch the replay, I'm telling you, if you do not have a will, you need one. Get one. But when it comes down to a trust, you may not necessarily be at the place where you just need that right now, but it's a tool that you have. So talk to your attorney about it, and then you plan out when's going to be the best place for you to, when is the best time for you to get that in place. All right. What about book royalties? Oh, yeah. So you can have it. You can have it where the royalties for books that you have written go into a trust. You can. And then what do you want to happen to those royalties? Do they just accumulate, and at some point in time, they're going to be distributed to beneficiaries? Will some of those, a certain percentage of them, be utilized for investments? Various things. Any asset that you have, you can put it into a trust, and you can control what is going to happen with those. Because you may have some people, like I say, maybe they don't have children, they didn't have pets, they don't want to leave it to any one particular person. They have a charity that's near and dear to their heart, and so hey, they're gonna say, look, you want to know something? I was best-selling author with all of these books. I'm having all these royalties that are coming in. I'm gonna create a trust so that my trust can, have these royalties. And guess what? I want it to go to this organization. Now, I'm not going to get into the aspect of contracts with the businesses and what that looks like as far as royalties when they stop, when they end. I'm not going to get into that aspect of it. But if you got book royalties coming in and they're supposed to continue even once you have passed, trust is an avenue or a tool that you could utilize to be able to allow those to overflow or roll over into the lives of your beneficiaries or various other individuals. Yes. So with that, we have probably about 5 minutes or so. Let me throw this question out there. So for those who are on the live, what is another topic of interest that you all are interested in that we could potentially pose or push out for next Wednesday? Like I say, we want to serve you all. What is of interest to you? Because I'm pretty sure that we could come up with various topics. We can come up with so many different topics. But of course, those that are most important to you all, those are the ones that we want to come and we want to answer your questions. Those lingering questions that you had, and you're just like, I wonder, I had this issue come up, or I had that come up, and I really didn't know who to go to, and sometimes it's just like, oh, well, I didn't have this this fee for the consult, but I need this question answered. Or these have come to me from, I've heard it come up with family and friends and all those different things. What are your thoughts? If you have some ideas, go ahead and drop those into the chat. And if you don't, look, that's totally fine as well. We're gonna put a post and we're gonna be asking y'all, what do you have? So even if you don't think about it now, you will definitely have the opportunity. But the floor is open. Should you all have any particular topics, areas of concern that would be of interest to you or interest to those that you know, your families, coworkers, friends, you put them out there. But with that being said, while we are kind of giving time for people to do that, if you all have not already, you can scan this QR code. All of our contact information is there. If you have a question, you need to book a consult, you have a individual situation that's going on that needs more clarity, reach out to us. What to do when you are involved in a car wreck? That is a good topic. That is a good topic. We have a lot of those cases that come in, and so that is probably definitely maybe our next one. Workers' comp. That may be something that we can explore. It's not necessarily one of our focal areas, but of course, knowledge is power. And so we're knowledgeable of some things. We may not handle them, but we could probably come and get you all the information that you need for those particular questions. So great ideas. Also, if you're not already following us, IG, follow us on Instagram, follow us on Facebook, follow us on LinkedIn. We're always sharing information. I mean, we have our legal minutes. We're pushing out newsletters. So go to the website, get signed up for the newsletter that we come out, and we won't bog you down. We will not spam you with emails every day. Once a month, we send out a newsletter on particular topics and just a recap of the month, what's going on, things that we think would be of benefit to you all and to those that you know. So, go and get that information. Make sure that you're following us. Like I say, at the end of the day, we are here to serve you. Our purpose is to be your trusted advocates for justice and peace of mind. People have various legal issues that they deal with and that come up. And the thing is, we're telling you, look, you don't have to do it alone. Let us come beside you. Take that stress off you. I tell clients this all the time. It's now that you've hired me, now that you've retained me, now that you've been appointed to me, let me stress for you. And there's no stressing, but let me carry that burden for you. And we're going to get all this worked out. All right. Immigration. Yes. That is also another good topic. Yes. So my team, we're going to get together and we're going to brainstorm about this. And what's going to happen is you're going to get a post. It may be Friday. And it says, hey, this is going to be the topic. And when we throw out those topics, you all don't have to wait till you come to the live to post your questions. No, you can put them under that particular, that post. You can send them to us. Jump in the DMs. It's okay. Jump in the DMs and we'll make sure we're noted and we will make sure that they're being addressed, right? Share with us what you need to know. Child custody or divorces, child support in custody, amazing topics. And I will tell you all, we're planning on all these different ones. That's all information we're going to be bringing to you. It's things that we have stories, we have experience, we have things. And so even in answering these questions and making sure that everybody's equipped, they know which way to go, it's also to say, hey, if you need us, reach out because we truly are here to help you. We practice in Texas, Mississippi, and Georgia. And guess what? If you're somewhere else and it's not in those states, reach out. We have colleagues that we work with. We can get you connected with some people who you will be in good hands. And I tell people this also, even if you think you're like, I'm not really sure if they practice this particular area of law at McCray Stewart and Associates, call us. Because if we don't, we know somebody who does. All right. So we truly, truly do care about you all and any legal issues that you're dealing with and just making sure that at the end of the day, you're going to be taken care of. All right, y'all. It was an amazing time meeting with you all this evening. You all be blessed. And we're looking forward to seeing you again at Wise Counsel Wednesdays. Good evening, everybody.